Hello, doctors. I'm Dr. Chris Rapoff of DC QME Continuing Education, and welcome to this week's Case Law Update. This week, the Workers' Compensation Appeals Board is asked to reconsider a prior ruling provided by a workers' compensation administrative judge. Here, the applicant felt that the QME in this case provided the required evidence that qualified his report as substantial medical evidence, specifically when it comes to adding versus combining her factors of disability. Well, the defense disagreed. Also, the appeals board in the reconsideration ruling made not so much a subtle reference to remind all the parties that who's the boss. Let's get a lot of these particulars in this case, and I'll let you be the judge. So today we have the applicant, Ms. Gina Davis, seeking reconsideration of the findings of fact and award issued by a workers' compensation administrative law judge in August of 2023. This is when the law judge found that the applicant, Ms. Davis, did not rebut the combined values chart in the 2005 Permanent Disability Rating Schedule, and also Ms. Davis's bilateral hands and wrist injury caused 89% permanent partial disability. Now, Ms. Davis contends that the opinions of a physical medicine and rehabilitation QME were substantial evidence that her factors of disability should be added and not combined, and would result then in an award of 100% permanent disability and not merely the 89% permanent partial disability as determined by the judge. This touches on and makes reference to a prior 2013 appeals board decision. You may be familiar with it, the Kite decision. The Kite decision was a landmark decision in California workers' compensation law, and it held that when determining permanent disability, one should add rather than combine the permanent disability arising from multiple injuries if there is substantial medical evidence that the impairments have a synergistic effect and the resultant impairment is more than the sum of the two impairments separately. So Ms. Davis began working for Oracle America in September of 2007, some 15 years ago. So she initially claimed a cumulative trauma injury to her bilateral wrists and her hands while employed by Oracle as a global trade compliance specialist during the period from April of 2015 through April of 2016. She had a QME examination, and initially they evaluated Ms. Davis in June of 2016. After examining her, taking a history, and reviewing the medical record, the QME concluded that she had not reached PNS status. Now, her primary treating physician reevaluated Ms. Davis again a year later in 2017 and issued various supplemental reports. Ms. Davis underwent a course of treatment and then finally in June of 2021 was reevaluated by the QME, and after his reexamination and review of the interim medical record, he concluded that she now had reached permanent stationary status and that her permanent disability was 100% related to the medical treatment and her resultant CRPS, if you recall, complex regional pain syndrome, and then apportionment to any pre-existing or condition was not appropriate. In his report, when addressing the issue, Ms. Davis's work restrictions, permanent disability, and adding versus combining, he had a lot to say. First, let's talk about the work restrictions. And I'm quoting from his report. He says, "Frankly, I think I erred in a prior report and should have described her as being limited to light work with her upper extremities. Now, regarding the term repetitive use, this term has to do with things meaningful, as I do not believe she could engage in repetitive activities such as typing, sorting objects regardless of the size on a regular basis, or other similar tasks. Regarding the term forceful use, she basically is unable to apply force when using her upper extremities, and this would be limited to a light type of work activity. With regard to work status, he said, in terms of her work status, that she could not return to her previous job. was not medically probable that she could re-engage in the open labor market, and that she had a disability to her upper extremities, precluding right upper extremity use, and for the left upper extremity, no heavy or forceful repetitive use. With regard to adding versus combining, he mentioned, well, there are two methods to rebut the CVC table: then, add, and combine. So if an impairment has no overlap on ADLs, adding is appropriate. If there are overlapping ADLs with a synergistic or amplifying effect, then adding is also appropriate. However, in this particular case, while there is evidence of an overlap, the synergy between the upper extremities supports adding rather than combining. So it's very interesting when they talk about the synergistic effect, because this has become very popular. And I don't know if you noticed this in many of our cover letters that were requested to answer with regard to those. So the parties proceeded to trial in February of 23, not long ago, and the matter was continued for additional testimony by Ms. Davis. At the May trial, May of 2023 trial, the matter was submitted for a decision, and the issues submitted included permanent disability and apportionment. Okay, so the appeals board made a preliminary review of the trial record, and they raised several issues with this case. First of all, on the adding versus combining. Regarding her argument that her factors of disability should be added and not combined, the QME stated in his opinion that her factors of disability should be added rather than combined. Okay, we know that. But the appeals board had previously held that a disability values of multiple impairments may be added instead of combined using the CVC if adding the impairments provides a more accurate rating of the injured worker's disability. Here's where the kicker is. However, for his opinion to constitute substantial medical evidence, the QME must set forth a more complete analysis and explanation for his opinion, not just conclusions. And they stated and cited the Escobedo versus Marshall 2005 decision. And with regard to work activities, they said, well, Ms. Davis's ability to engage in certain work activities, the QME stated, quote, I do not believe she could engage in repetitive activities such as typing, sorting objects, regardless of the size, on a regular basis, or other similar tasks. He discussed the forceful term as well. But the appeals board reiterated that based on their review of the entire record, it appears that Ms. Davis may have a lost use of both hands, which would result in 100% total disability. However, she has lost the use of both of her hands is a medical determination and not a legal determination. Therefore, they said it must be addressed by the reporting physicians. And they concluded this portion was stating that although her loss of use of both hands may be inferred from the QME statements, as noted, for it to be substantial medical evidence on the issue, the QME must provide a more detailed explanation to his actual opinions regarding the applicant's ability to use her hands and must explain the basis for his opinions. Again, citing S.P. Marshall. Now, finally, there was another issue here. They were discussing sub rosa videos, which this is the first time we've heard of them. Finally, there were surveillance videos of Ms. Davis taken in October of 2019. Keep in mind she was heard in 15. 2019 videos, 2019 in October and November, June of 2021, and August of 2021. And the appeals board said that it appears that the QME was not provided the surveillance videos to review. And again, they reiterated, to constitute substantial evidence, a doctor's opinion must be based on an adequate examination and history. Thus, the QME must be provided surveillance videos in order to accurately assess Ms. Davis's level of disability. Okay, and then also the appeals board reminds us for some reason that a workers' compensation judge and the appeals board both have a duty to further develop the record when there is insufficient evidence on an issue. The appeals board has the constitutional mandate to, quote, ensure substantial justice in all cases, and the board may not leave matters undeveloped where it's clear that additional discovery is needed. And I assume they're referring to this case. They do state that the appeals board may appoint one or more workers' compensation administrative law judges in any proceeding as it may deem necessary or advisable, and may refer, remove to itself, or transfer to a workers' compensation law judge the proceedings on any claim. So therefore, in order to expedite this case and handling of this matter, they will order the matter to status conference before a workers' compensation judge at the appeals board. And finally, they indicate that in order to expedite the handling of this matter, they're going to order the matter to a status conference before the appeals board, as I had mentioned. However, they indicate that the appeals board is a constitutional court, hence its final decisions are given res judicata effect. What is this, you ask? Res judicata is defined as a matter that has been adjudicated by a competent court and may not be pursued further by same parties. So it appears that the appeals board is explaining to the parties that their decision or ruling is final and no other appeals could be filed. So as a result, the appeals board granted Ms. Davis's petition for reconsideration and ordered that a final decision after the reconsideration is deferred pending further review of the merits of the petition for reconsideration. Interesting why they decided to tell us that they're the boss. Well, in conclusion, we have another interesting case here that really touched on several subjects. First, we get a reference to the landmark Pike decision. And second, we get another reminder of the importance of providing a QME report that qualifies as substantial medical evidence. And finally, a strong reference made by the appeals board as to who has the final say in these sometimes very complex California workers' compensation cases. Just in case we forgot, we now know and are reminded who the boss is. So once again, I'm Dr. Chris Rapoff. I wanted to thank you for taking the time to join me in this presentation. I hope you've enjoyed our time together as much as I've enjoyed sharing these interesting cases with you over the past year. And I wish you luck in your endeavors to be the best QME that you can be.